Yeah, Manshi will start. I've started recording.
Yes, sir, we can start. Joel is also here.
Yeah.
Good afternoon, everyone. Firstly, I would like to know if I'm clearly audible.
Yeah, you're audible. Yeah.
All right, great. Good afternoon, everyone, and welcome to the NUJS International Law Student Association guest lecture on Russia-Ukraine conflict and its implication on international law. Gracing us this afternoon for the lecture is Dr. Sergey Sayapin. Dr. Sergey Sayapin teaches and researches in the areas of international and criminal law and is among Central Asia's leading experts on international conflict and security law. Dr. Segey studied law and graduated summa cum laude at the University of World Diplomacy and Economy in Uzbekistan. Furthermore, he holds various other degrees from prestigious universities worldwide, including the University of Essex and Humboldt University, Germany, to name a few. From 2000 to 2014, Dr. Segey worked in the communication department at the Regional Delegation of the International Committee of the Red Cross, ICRC, in Central Asia. He also regularly advises the ICRC and Central Asian state authorities on international law issues. In 2019, he contributed to the revised edition of the Criminal Code of the Republic of Uzbekistan. Currently, Dr. Segey is an associate professor at the School of Law at the Kazakhstan Institute of Management, Economics and Strategic Research, KIMEP. With this introduction of our guests this afternoon, I now hand it over to Dr. Atul Alexander, our faculty advisor, to give his opening remarks. Sir, over to you.
Thank you, Joel, for that. Hope I'm audible and hope I'm visible too. Firstly, I would like to profoundly thank the resource person of the day, Sergey Sayapin. There is a specific reason for I'm inviting Professor Sergey Sayapin. Because Sir has written extensively on the Russia-Ukraine conflict, and this has been widely cited. And his area of specialization is predominantly international law and international criminal law. His writings especially focuses on the theme of Central Asia, and I've been a staunch follower of his writings in leading journals which were published by leading publishers like Oxford, Cambridge, Brill, and Springer. And he writes extensively in blogs, and he in fact has given a thorough or comprehensive writings on the Russia-Ukraine conflict, which is something as a student of international law myself and all of you should be aware of. Now, to give a brief context of the entire conflict that is ongoing, the conflict presented a fresh or reorientation of the international law that we see today. And some scholars have argued that there is a kind of crisis in the existing international law, because of which the ongoing Russia-Ukraine conflict is still continuing. For instance, various international forums were approached by Ukraine, for instance, the ICJ, wherein ICJ gave its provisional measures in stating that or directing Russia to stop the insurgency in parts of eastern Ukraine. The prosecutor of the International Criminal Court has also taken up the issue, and states around 40 states have submitted a request under Article 12, Para 2, Para 3 of the Rome Statute. The UNGA passed a resolution condemning the acts of Russia, although the resolution did not see the end of the tunnel in the Security Council, courtesy the Russian veto. And recently, if I'm right, yesterday I also came across a blog post which talks about the extraterritorial application of human rights. The question of extraterritorial application of human rights with regard to the violations committed by Russia in the eastern part of Ukraine, the regions of Donbass. Uh, so to highlight the contours and the intricacies of the ongoing conflict, as introduced by Joel, we have an eminent and a doyen personality with us today, Professor Sergey Sayapin. Uh, as I've introduced him, Sir today would be addressing us on the topic Russia-Ukraine conflict and its implication on international law. The format of today's discussion would be Sir would be addressing us for 45 minutes, followed by the Q&A, that is question and answer, or your questions can be posted in the chat box, or you can directly, maybe direct your questions at sir. Sir would be happy to address your questions on the topic that is being discussed today. With this, I hand it over to sir to address the gathering. Thank you.
Thank you very much, dear colleagues. Thanks for inviting and having me today, and I am pleased to address you and to share some of my views on the topic. In fact, the topic is highly important, and although the conflict formally involves two countries, it certainly has broader implications. It has implications for the states which provide Ukraine with military, political, and economic support. It concerns states in various regions of the world, and you can feel various kinds of its implications in your country as well as I am sure, as we are feeling the implications of this war here in Central Asia. To give you just a few examples, in anticipation of sanctions which gradually were introduced against Russia, against the Russian financial system. So many Russian citizens started transferring their funds to the banks of Kazakhstan, of the country where I am living, in order to try to save some of their money. As a result, the economic dynamics in the post-Soviet region are now visibly changing. Also, since February 2022, but especially since September, when Russia's President Putin announced the so-called partial mobilization, hundreds of thousands of young Russian men of military age, arrived in particular in Kazakhstan, but also in some other post-Soviet nations and in other countries of the world. These are men who do not themselves want to be recruited in the army, who do not want to participate in hostilities with Ukraine. Some of them are against the war. Not everyone is, but the fact is that those hundreds of thousands young men who have left Russia in 2022, they do not want to participate in hostilities of their country against Ukraine, which of course is significant for the war effort, but it is also significant, for example, in economic terms. It means that the Russian state has lost uh, well, close to 750,000 of largely qualified, young, competent workforce. And now these men and very often their families are abroad. They are not in their country anymore, and thus they are contributing to the economies of other countries. Uh, In November last year, I had a fellowship at the National University of Singapore, and even in Singapore, I was told that some effects of the war were felt there, as distant as Singapore is geographically from Eastern Europe. Well, mostly economic effects, and so this war is a challenge to the entire international system in terms of security, in terms of economy, in terms of international law, and certainly the world is going to be different after this war is over, sooner or later. If you think about it, the conflict was to be anticipated because already in the 1990s, soon after the collapse of the Soviet Union, a famous American political scientist, Zbigniew Brzezinski, almost predicted this conflict. In his book, The Grand Chessboard, he analyzed the possible implications of the collapse of the Soviet Union for international security, and he made a supposition to the effect that sooner or later Russia would want to reestablish its quasi-imperial influence in the post-Soviet space, that it would sooner or later it would try to consolidate its political, military, and economic power among its neighbors who decided to leave it in 1991. And he wrote that Ukraine would certainly be the main target of Russia's influence because of its size. So if you think about it, Ukraine is the largest European state in terms of territory. It's bigger than any other country in Europe, except the European part of Russia itself. So it's very big in territorial terms. It has vast natural resources. It has vast human resources, but very importantly, it has an immense cultural significance to Russia itself, because uh, uh, because the history of Ukraine, the history of its capital Kiev, started. The known written history started much earlier, and to Russia, it is very significant in political cultural terms to be together with the cradle of the Eastern Slavonic culture, which is Kiev, and to exercise control over it, which in turn means that it is crucial for Kiev to get independent from Moscow's influence and to look westward or in the direction of Europe. And so that is essentially the cause of the conflict, in Zbigniew Brzezinski's words, that without Ukraine, Russia cannot be an empire. It cannot claim to be an empire without such an important country as Ukraine being with Russia and on Russia's side. So in that sense, the conflict was to be anticipated. And but even so, it was a big surprise to people in this part of the world when in February 2014 Russia started the annexation of Crimea. You will remember that that process took about a month. It started in February. It was formalized in terms of Russian constitutional law in March 2014. Then in the spring and summer of the same year, the conflict in the eastern part of the country intensified, insofar as Russia started providing support to pro-Russian separatists in two regions of eastern Ukraine, and the hybrid phase of the conflict lasted until February 2022. One important point I would like to make here is that international reactions under international law have not been as significant as they probably should have been during the first 8 years of the conflict. Yes, some foreign states did introduce some limited sanctions against Russia, but the reactions were not as strong as they should have been. In fact, if you think about it, what happened in 2022 might not have happened at all if, for example, the international community had reacted more resolutely in 2008 when Russia used military force against Georgia. If sanctions had been stronger already in 2014, then the full-scale invasion probably would not have started in 2022. But now that the conflict has reached this new stage, uh, I would claim that, unlike some colleagues now speak about international law, I would claim that actually now international law is at the height of its power. I would claim that international law has never been so consolidated, and never has a very large group of states been so keen on using the instruments supplied by international law against the aggressor. Never before in history has the General Assembly of the United Nations passed so many resolutions in just 1 year condemning a state which had committed uh, aggression against another state. Very rarely before did the General Assembly name a state using military force in violation of international law by name. But in 2022, this happened more than once, and Russia was named very clearly in the General Assembly resolutions as an aggressor state. Never before have so many sanctions introduced as against a single country. So Russia is now the most sanctioned country in the world. Uh, the sanction burden again introduced against Russia is even greater than that, for example, introduced against Iran. So the uh, Russia's place on the international political arena is changing. It is now trying to, well, maintain as many alliances as it can. It is now trying to reshape its international economic relations. Uh, However, it is becoming increasingly clear that uh, this conflict will change uh, the uh, the future design of the world. That there will be very, very important implications for international security, for the law of international security, and also for international criminal law once this conflict is over. If you would like, we could discuss some of these questions in the Q&A session. But in the rest of my talk, I would like to focus on an issue which is less frequently discussed in the academic discourse. And probably this will be of interest to some of you, and ideally to most of you. I would like to discuss the way Russia has been using the language of international law since February 2022 in order to show, at least this is my understanding, that Russia had not been taking international law seriously. So the way they spoke about international law since February 2022 suggests to me that they were not thinking that international law was very serious, and therefore they were using the applicable terminology quite lightly, obviously incorrectly, and in manipulative ways. So, with your permission, let me now give you a few examples, which hopefully will show what I mean, and then I will suggest a few conclusions and recommendations in the end. You will remember that shortly before the full-scale invasion on the 21st of February 2022, President Vladimir Putin signed 2 decrees on the recognition of the so-called Donetsk People's Republic and the so-called Luhansk People's Republic. These are 2 separatist regions in the eastern Ukraine that Russia has been supporting since 2014. The texts of both decrees were essentially identical. They referred to the expression of will by the respective peoples. They called for the establishment of diplomatic relations with the Russian Federation, and they committed the Russian Federation to ensuring the peace support functions in both respective territories until the conclusion of treaties of friendship between these territories and Russia. So this happened on the 21st of February. On the 22nd of February, the very next day, the Secretary General of the United Nations called Russia's rhetoric a perversion of the concept of peacekeeping. The Secretary General said explicitly that when troops of one country enter the territory of another country without its consent, they are not impartial peacekeepers. They are not peacekeepers at all. End of quote. Putin's reference to peace support functions was a mockery of international law, also because it was meant to be exercised only until the conclusion of treaties, as I mentioned a minute ago, with both separatist territories, which happened already on the 22nd of February, making the purported peace support functions the shortest of their kind in history. They lasted only for 1 day. And on the 22nd of February, when the so-called treaties were signed with both territories, it became obvious from the treaties that the contracting parties should provide each other with necessary, including military assistance in the exercise of the right of individual or collective self-defense in accordance with Article 51 of the UN Charter. So both treaties stipulated that, and already 2 days later, the use of force by Russia against Ukraine began. And you may remember that in his televised address of the 24th of February, Vladimir Putin mentioned self-defense as a justification for the special military operation that which started on the same day. Please note that he supported his argument by an explicit reference to Article 51, Part 7 of the UN Charter. Unless he misspoke and meant Chapter 7 of the UN Charter instead, he technically referred to a non-existent provision, because there is no Part 7 in the UN Charter, there is Chapter 7. If Putin did mean Article 51 of the UN Charter, he must have misinformed his audience by not mentioning that the exercise of the right to self-defense in the sense of Article 51 requires the existence of an armed attack against a member of the United Nations. Obviously, Russia itself has not been a victim of Ukraine's armed attack. Moreover, even if Putin wished to claim that his new allies, the so-called Donetsk and Luhansk People's Republics, had themselves been the victims of Ukraine's armed attacks, he might still not invoke Article 51 of the UN Charter, because those so-called republics are not members of the United Nations. So, as hypocritical as the invocation of self-defense was in that context, an attempted reference to the inherent nature of the right to self-defense under customary international law would have been formally more convincing and more correct. So you see, this example alone shows how manipulatively the language of international law was used in that situation in order to try to justify the unjustifiable. And to me, it does suggest that the Russian authorities were not taking both the language and the substance of international law seriously enough. Let's go on. In the same televised address, Putin has euphemistically referred to Russia's attack against Ukraine as a special military operation, and this terminology is still in use until today. However, please note that this concept does not exist under international humanitarian law. Under IHL, the proper terms would have been war or international armed conflict in the sense of Article 2, common to the 1949 Geneva Conventions. However, obviously, Putin could not use any of these terms because the aggressive term war would not have been approved by his supporters, probably, or at least by some of them. And the meaning of the technical legal phrase international armed conflict may not have been understood by some of them. In turn, a special military operation sounds more positive. It implies a relatively short duration and suggests a likelihood of success. It may be recalled in this context that the annexation of Crimea in 2014 was officially referred to in Russia as the operation for the alignment of Crimea. You see, in the same spirit, it sounds somewhat positive. It implies it was quick, and the phrase implies it was successful. It has been reported that the Russian authorities were hoping before the invasion that this so-called special military operation would be very, very quick. According to some reports from captured Russian soldiers, they were carrying with themselves their festive military uniforms in the hope that after only 2 weeks, they would be marching in the streets of Kiev in a military parade. That was the hope of the Russian authorities because they thought the Ukrainian army was weak, absolutely unprepared to resist. They were hoping that a very, very significant part of Ukraine's population would welcome them literally with flowers and bread, which did not happen. And very likely, the Russian authorities had not expected such a strong and consolidated reaction on the part of a large part of the international community in support of Ukraine. Why so? Because there was no consolidated reaction in 2008 after the use of force against Georgia, because international reactions to the annexation of Crimea in 2014 were very, very limited. And so they must not have thought that a significant part of the world with considerable economic and military resources would unite in Ukraine's support. And so the so-called special military operation was a failure. It did not finish in 2 weeks. The Russian army was not welcomed in Ukraine with bread or flowers, and the conflict turned out to be very violent, very bloody, with tens of thousands of victims, military and civilian, with many millions of refugees, with entire cities destroyed in violations of all possible rules of international humanitarian law you can think of, and the conflict will soon be approaching its first anniversary. So the special military operation was not successful. First, because the people of Ukraine themselves showed an incredible spirit in resisting the enemy, and also because Ukraine as a state received very, very significant political, economic, and military support from their allies. Let me give you the next example, which I consider important. It concerns the use of the concept of genocide in this conflict. In the same televised address of the 24th of February 2022, President Putin alleged that Ukraine was engaging in a genocide of Russian speakers in eastern Ukraine. Actually, this argument was not new. Already in 2014, Russia's investigative committee instituted criminal proceedings on charges of alleged genocide of Russian speakers. And in 2018, I discussed in a book chapter why those charges were wrong in the sense of the 1948 Genocide Convention and Russia's own criminal law. In brief, this argument was wrong because the crime of genocide does not cover linguistic groups. So the invocation of this crime with respect to Russian-speaking persons in Ukraine is incorrect. The concept of genocide only covers national, ethnic, racial, and religious groups, but not linguistic groups. Likewise, the Russian Federation has no criminal jurisdiction with respect to alleged genocide committed abroad, because in accordance with the convention, such exclusive jurisdiction is limited to territorial states and to the International Criminal Court. And extending such jurisdiction extraterritorially for the purpose of protecting compatriots abroad, as Russia calls Russian speakers abroad, is not in conformity with international law, and it could be invoked by Ukraine as a violation of general international law. This is what I wrote in 2018. And indeed, 3 days after the invasion, on the 27th of February, excuse me, Ukraine invoked a similar argument and filed a claim against the Russian Federation before the International Court of Justice. More specifically, in that claim, Ukraine has emphatically denied the charges of genocide and stated that Russia has no lawful basis to take action in and against Ukraine for the purpose of preventing and punishing any purported genocide. End of quote. At this time, Ukraine's claim has been supported by more than 40 states and the European Union, and the interstate proceedings are ongoing. Let me, in conclusion, let me show you how Russia was mistreating the concept of aggression and crimes against peace since 2014, and I hope this will provide enough background together with the previous arguments to my main claim that Russia was not taking international law seriously enough, and now that the international community has largely consolidated in its resistance to this ongoing aggression, well, this should be a lesson to the Russian authorities with respect to the importance of international law. So, a few words about crimes against peace. You will remember that since February 2014, Russia was actually systematically denying its involvement in within the hostilities in Ukraine. They were always saying there was an internal conflict with Ukraine between the central government and some non-state actors, but Russia had allegedly nothing to do with it, which of course was wrong. You will recall that when in February and March 2014, the so-called Little Green Men who took control over Crimea, but the official involvement of Russia was denied. Then it took at least a year and a half for President Putin to acknowledge the presence of the Russian military in Donbass, in eastern Ukraine. On the 5th of May 2014, notably, Russia effectively decriminalized its nationals' participation in military units in the territory of a foreign state, which are not provided for in the legislation of that state, where the aims of such participation would not contradict the interests of the Russian Federation, and thus effectively legitimized under its penal law the presence of thousands of Russian volunteers in eastern Ukraine. So, in simple terms, Russia got rid of criminal responsibility for the participation of its nationals in armed conflicts abroad, and this enabled thousands of professional military and volunteers to go and fight in Ukraine. You will remember that even after the verdict pronounced a few weeks ago by a court in the Netherlands in the MH17 case, Russia still continues denying its role in the downing of the MH17 flight on the 17th of July 2014, despite overwhelming evidence to the contrary. Shortly before the invasion, on the 25th of December 2021, the spokesman for the President of Russia, Dmitry Peskov, claimed, and I quote, that Russia never attacked anyone first, end of quote. Already on the 8th of February 2022, Putin himself stated publicly that Russia was posing no military threat to Ukraine. And of course, at the time, he already knew there would be an invasion in just 2 weeks' time. The full-scale invasion of Ukraine, as we already know, was euphemistically termed a special military operation for the demilitarization and denazification of Ukraine. And in Russia, thousands of individuals have already been held liable, among other things, for calling the operation a war, for calling for peace, for refusing to display the Z or V signs, which became Russia's official symbols in that war, or for criticizing the government. You may know, or if you don't, I'll tell you that a prime example of Russia's policy of denying the obvious was a statement made on the 10th of March 2022 by Russian Foreign Minister Sergey Lavrov to the effect that Russia had not invaded Ukraine. Just think about it. The invasion began on the 24th of February, and on the 10th of March, the foreign minister was still saying that Russia had not invaded Ukraine. And at the end of March 2022, the Secretary of Russia's Security Council claimed that Russia was not bombing Ukrainian cities, which of course was not true. So to sum up, and after that, I'll be happy to turn to your questions. To sum up, it's obvious that the current Russian government is definitely not interested in objective fact-finding about its use of force against Ukraine, and it does all it can to misinform its own population and supporters abroad. This policy is fairly successful, given that only about 15% of Russia's population masters foreign languages fairly well. And therefore, an overwhelming majority of Russians do not have access to foreign media where alternative views are presented. In the past year, many independent media outlets were closed or expelled from the country. Please note that according to the official statistics given by the Russian Ministry of Communications, only 5% of the population does not watch television. which explains the outstanding effect of the televised state-sponsored propaganda for war. On the Russian television, there is propaganda for war in the news, on TV shows, in various other formats, 24 hours a day, 7 days a week. And so, given that 85% of the population do not speak any other language except Russian, and given that 95% of the population watch TV, so this does explain the powerful effect of the propaganda for war. Plus, if you couple these factors with Russians' traditional respect for authority, with the fact that, well, at least suspicion, but also sometimes hatred for, especially for the West, is cultivated in Russia. So, as a result of all these factors, well, about 72% of Russians are now supporting what they call the special military operation against Ukraine. Only 17% are not supporting it, and 11% find it difficult to answer. So let me stop here, and I hope to be able to answer some of your questions very soon. As you see, the situation is very, very complex, and we have covered just a few issues to show you the complexity of the situation. But if there are any questions, I'll be happy to attend. Thank you.
Thank you, Professor Sergey Sayapin, for that comprehensive discussion on the Russia-Ukraine conflict. You aptly summed up the language used by Russia to essentially argue in international law in its favor, and how it has used the language of international law in this regard, especially in the context of the right that is enshrined in the UN Charter, that is self-defense, and the 1948 Genocide Convention. So now we come to the question and answer. We have a question by Ravi Singh. So Ravi, you might direct your question to Professor.
Good afternoon, sir. My question is regarding this mockery of international law. Like US and Europe also doing the same. They are providing arms and ammunition which have no legal justification. They are imposing sanctions which have no legal justification. Everyone is doing the same, and the Security Council and the General Assembly is quite on that. What they are doing, they are not resolving the dispute. They are increasing that, and is imposing sanctions and secondary sanctions also have no legal justification in international law.
Thank you very much for the question. Let me draw your attention to the articles on responsibility of states for internationally wrongful acts. You will remember that this document was developed by the International Law Commission and promulgated by the UN General Assembly in 2001. So although the articles on state responsibility are not a treaty, and therefore they are not legally binding as a treaty, they are usually perceived as a reflection of customary international law, because the International Law Commission, when writing the articles, analyzed extensively relevant state practice and formulated the rules on state responsibility on that basis. And so, in the articles on responsibility of states, there is Article 42, which relates to responsibility for grave breaches of peremptory norms of general international law, that is, of jus cogens norms. The prohibition of the use of force under Article 4, paragraph 2 of the UN Charter is certainly a peremptory norm of general international law. It is generally regarded as a rule of jus cogens, and therefore the responsibility of states for violations, in particular of the prohibition of the use of force is regulated by Article 42. What does it tell us? It tells us, on the one hand, that states should not recognize as legally valid any changes, any factual changes brought about by violations of the jus cogens rules. So in our situation, by the use of force by Russia against Ukraine, the annexation of Crimea should also not be recognized as legally valid under Article 42. The same provision also tells us that states should cooperate. They should work together by lawful means to bring to an end of the situation that was caused by a violation of the jus cogens norms. In our case, it means that like-minded states should provide Ukraine with military support, as they do, in pursuance of Ukraine's inherent right to collective self-defense. So, in that sense, in the context of Article 42 of ARSIWA, of Articles on the Responsibility of States for Internationally Wrongful Acts, sanctions introduced against Russia are lawful, and military, economic, and political support which Ukraine is receiving is also lawful. Thank you very much.
Thank you so much, Professor, for that. We have a question from Bipro Pratim Das. Bipro, can you go ahead with your question? Yeah. Bipro, you're there? I mean, it seems your hand, yeah, it's raised. Yeah. Okay, fine. There's a question that is posted in the chat box. Sir, I'll read it for you, if that is fine. Why linguistic groups are not covered under genocide? I think he is referring to the Genocide Convention.
Thank you. Indeed, I saw this question, and the question is complex. In fact, one could argue that linguistic groups are indirectly covered by the Genocide Convention, because language is could be regarded as an element of ethnicity or as an element of nationality, and both national and ethnic groups are covered by the Genocide Convention. However, and this is my attempted answer to the question. However, linguistic groups were not explicitly mentioned as protected groups in the Genocide Convention, because in our increasingly interdependent world, well, very often people speak multiple languages. Take the example of Central Asia. Take the example of India, where people are often multilingual, and so the very fact that a person speaks a certain language does not ascribe that person to one of the 4 protected groups. We are here in this session, people from India and from Central Asia, holding the session in English. For none of us is English a mother tongue, so it's well, I suppose that for most of us it's the second language, but nonetheless we are using it professionally for a professional purpose, and it would be difficult to qualify English in the context of us, people in this setting, as a factor ascribing us either to a national, to an ethnic, to a religious, or to a racial group in the sense of the Genocide Convention. In other words, the factors specifically, the protective factors specifically singled out under the Genocide Convention are inherent, natural, and sort of inseparable from the human person. You cannot change your ethnicity. You cannot change your race. True, you can change your religion, but as a matter of fact, it's not easy, because religions themselves often prescribe rules for not changing religions. Whereas language is a factor which can be acquired. If we speak multiple languages, it does not mean that through those languages we are automatically ascribed to the relevant ethnic, national, or racial groups. So, to sum up, since the language is not a factor inseparable from the human person, as the other four factors are, I presume this was because it was not included as a protective factor in the Genocide Convention.
Thank you, Professor, for that wonderful answer. It's very nuanced. And I come to Bipro. Bipro, you have a question to Sir? Maybe please go ahead and ask.
Sir, am I audible?
Yeah, you're audible.
Yes.
Yes. Sir, I want to thank you so much for this wonderful informative session. My question is all about that you said international law today is at the height of its power. So in that case, sir, how do we actually consider that to be the height of the power when it is unable to subjugate the atrocities that are going on against people, which is a gross violation of international humanitarian law as well as international law itself? What has international law to do with that? Yes, thank you.
Thank you very much, sir, for this very, very important question. Indeed, I meant what I said, that to me, international law now seems to be at the height of its power. Not because it was unable, unfortunately, to prevent the atrocities which are happening now. This is a fact. And they are happening probably because international law is relatively weak in comparison with the domestic legal systems. You may remember a famous statement by Professor Hersch Lauterpacht to the effect that international law is at the vanishing point of law, and the law of armed conflict is at the vanishing point of international law. So that is to say that international law itself is weaker than domestic law, and the law of armed conflict is weaker than the rest of international law. It's simply a fact. However, even with this fact, after 1945, there have been considerably fewer wars than there had been in the previous human history. Since 1945, most countries have faithfully followed the prohibition of the use of force under the Charter of the United Nations. And unlike until 1945, the use of force is now regarded as something abnormal, as a violation of international law, whereas until 1945, it was fairly accepted and acceptable under international law. So the point I'm making here is that it is true that international law still is violated from time to time to various extents. Sometimes violations of international law are very grave, such as the use of force between states or violations of international humanitarian law. But it seems to me that for the first time in history, we are witnessing a situation whereby there is such an extensive and consolidated reaction to an act of aggression. For the first time, has an aggressor state been subject to so many sanctions in so many different sectors of its economy? For the first time, after the Nuremberg and Tokyo tribunals, are there discussions to establish a special tribunal to hold the authors of this war of aggression criminally responsible for the aggression? Think about it. There were no criminal trials on charges of aggression in an international tribunal since Nuremberg and Tokyo for many decades. Now, some states are discussing a prospect of establishing a special military tribunal to try Putin and his team for crimes against peace. At this moment, we don't know when and how this will happen, but the very fact that there are extensive international sanctions against the aggressor, that there is so much and so well organized military and economic aid coming to Ukraine from foreign countries, the fact that uh, various formats of possible criminal responsibility of the authors of this war are being contemplated, this says that states are now increasingly realizing the importance and potential of international law in resisting acts of aggression. And I hope that this will be an important lesson to be learned by everyone from this
Thank
war.
you, Professor, for answering that. Maybe we'll take one more question
Thank you so much.
before we wind up the
Mhm.
session, if that is fine with you, Professor. Or,
Sure, absolutely.
or
Let's take one more. Let's take one more.
yeah. So Siddharth Chaturvedi has written in the chat box. So he wants to know. Good afternoon, sir. You stated that military operation is not recognized in IHL. However, by the same analogy, can it be claimed that the invasion by Afghanistan by United States could also not be covered under
Mhm.
international humanitarian law?
Thank you very much. Uh, Let me make myself clearer in the context of this question. Uh, I meant that the specific term special military operation that was proposed by Russian authorities to describe their military activity against Ukraine is not to be found in international humanitarian law. If you open up the Geneva Conventions or any other document of IHL, you will not find a phrase special military operation there. So, in other words, the phrase has no significance. It makes no sense under IHL. It is not a term of international humanitarian law. It was, if you wish, specifically invented by the Russian government to describe what it was going to do against Ukraine. And if we look at the situation from the perspective of international humanitarian law, well, it is an international armed conflict. And being an international armed conflict, it results in the respective rights and obligations under the Geneva Conventions and other sources of international humanitarian law. In the same sense, uh, the 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 international armed conflict between an international coalition led by the United States on the one hand, and Al Qaeda based in Afghanistan in 2001 on the other hand, was also an international armed conflict regulated by international humanitarian law with the resulting rights and obligations for all parties in that conflict. So the point I'm making here is that uh, well, it may be acceptable to various extents among politicians, among journalists, among other non-lawyers, that the terminology of international law, in particular international humanitarian law, in this context, is used not specifically enough. But as lawyers, we have to be very careful about the terms we use as professionals, and we have to critically monitor the discourse of other actors, such as political leaders, journalists, and others, in the way they use the terminology of international law. Because sometimes these can be simple mistakes, and sometimes, like I try to show in my presentation, it can be a consistent policy calculated to mislead the population. Thank you.
Thank you so much, Professor, for that. I'm not sure we have any more time to take questions. If you have any specific doubts, you can mail your questions to Professor. I guess Sir would be more than happy to address or take your questions.
Absolutely. This was also my suggestion. Please share my contacts with the participants and I'll be happy to answer questions by email. Thank you very much.
Sure. And I've also shared the books that Sir has written, the books and the blogs that Sir has contributed, specifically on Russia-Ukraine issue. And his writings, as I said, predominantly revolves around international criminal law. I've shared this in the Google, the chat box. So anyone interested can go and buy those books. Very interesting. And with this, we would come to the end of today's discussion. This was the sixth ILSA NUJS lecture series. From the bottom of my heart, I would like to profusely thank Professor. And in future, we also hope to hold a discussion on the book that Sir was referring to. We'll have a kind of comprehensive discussion on the book that Sir has authored recently, along with uh, other scholars. We plan to hold a discussion. I think we'll start the process. Maybe in a couple of days from now. I think Sir could share his book with me. I'll go through it and we'll have a discussion on that. And I also would like to say that we would like to hold more sessions, such engaging and intriguing sessions on, especially on the contemporary contours and aspects of international law. So I would also like to thank all the participants. I think today the turnout was around 42. Considering that, sir, we are celebrating Ethnic Day at our institution. Considering that, the turnout is really good. I would also like to thank the participants from outside our university, outside NUJS, who have joined for this session. I would also like to thank the HILSA members, specifically Joel, Manshi, and other members, Mehul, Tushar, etc., for contributing for the successful, uh, for the success of this, the talk. So with this, I will hand it over to Manshi to propose the formal word of thanks. Manshi, over to you.
Yes, thank you, sir. Respected Dr. Sergey Sayapin, our moderator and faculty advisor, respected Dr. Atul Alexander, and dear participants, it is my privilege to offer the vote of thanks today. I am Mansi Lodha of NUJS ILSA. Take this opportunity on behalf of the entire society to express our heartfelt gratitude for the informative and thought provoking talk. It was truly an enlightening session on the very burning issue of Russia Ukraine conflict and its implication on international law. It was indeed valuable listening to Professor Sergey. We're sure that all of the participants would benefit and the legal fraternity and social activists would benefit from this session in the continuing days and years to come. Secondly, we would like to thank Dr. Atul Alexander for moderating this session and helping us organize this session in a smooth manner. We would also like to thank our Honorable Vice Chancellor D.N. Chakraborty and faculty members of NUJS for their support and organizing sessions constantly. Finally, we thank all the participants for actively participating and asking such pertinent questions that made this evening session highly engaging for the budding lawyers and other watching this lecture. Thank you everyone for joining today. We at ELSA promise to hold such enlightening lectures in days to come. It was truly a privilege to interact with you, Professor Sergey. Thank you so much.
Thank you very much for having me. Thank you.
Thank you, Professor, so much. And we would also like to engage your scholarship in the near future. All the writings that you do and other scholarships, a kind of comprehensive discussion on all that. Thank you so much.
Thank you. We'll be in
Thank,
touch and I hope to meet you again soon. Thank you.
thank you. See you, Professor.
Bye bye.
Bye.